A very warm welcome to the third set of reading comprehension questions in the free LawPrep. This passage deals with a subject that is likely to be of interest to most law aspirants. Let me caution you though, that when you are solving questions on reading comprehension, you must be objective. Do not let your interests, disinterests, or your knowledge interfere with your comprehension of what is given to you in the passage. The reading comprehension section tests you exclusively on your ability to understand what is given to you, and remember that you are to treat what is given to you as the truth. Do not let yourself be misguided by your opinion, prejudice, or external knowledge. Let us go ahead and look at this passage.
Now here's the passage for you without the questions, available in a more legible font. Read it yourself, spend as much time as you need to comprehend it, and then we'll go for it together. Now let us go through this together in some detail, picking one or two lines at a time. We'll begin with the first paragraph. Now remember the importance of the first sentence, the first paragraph, the last sentence and the last paragraph. The first sentence is likely to lay down the plot of the entire passage for you. The last line is very likely to conclude it for you. Also, within each paragraph, the first line of a paragraph introduces that point to you, and the last line of a paragraph generally concludes that for you. Okay? So, when you see the first line, remember that it has a lot to offer. Okay, let's read the line together. It says, a major issue in international law today is universal human rights. So it's giving you the issue around which this passage revolves. Going ahead, these rights are considered general standards for the fair treatment of citizens by their governments, to which all persons, under whatever political system, are entitled. But what is the nature of these rights? Now, when you see a long sentence, okay, the second sentence, as you can see here, is kind of long. You can shorten it. And if you want to know the technique for shortening sentences, you can click on the link given to you in the I button in the beginning of the video. Okay? I've explained all the general principles for reading comprehension in there. Okay, it says, under whatever political system, you can just strike this off. It says, now read the sentence, you'd find it a lot easier. These rights, which rights? Universal human rights, are considered general standards for the fair treatment of citizens by their governments, to which all persons are entitled. Once you understand that, you can add this back, under whatever political system. Now, you can see also from the first paragraph that the first sentence and the last sentence are really laying out the problem for you as well. It says that a major issue is universal human rights. But what is the nature of these rights? This is the problem. Okay? So, universal human rights, regardless of the political system, they should be available. But what is the nature? This is the problem. Let's read this together. It says, one view is that rights depend exclusively on political structures. Now, even before I proceed, I want you to understand that it says that there's one view. Now, if you're reading actively, do you realize that you're now going to look for another view somewhere in the passage? Because if it were talking only about one view, why would it call it one view? It definitely means there's another view lurking somewhere in here, and you will have to see it. Okay, so stay alert. Do not read this passage just by looking at the words as they come. That's really not going to help. Be an active participant. Engage with the passage. That's when you'll be able to comprehend it, and that's when you can get the questions right. Let's move ahead. It says, under this view, okay, people have rights only by virtue of belonging to a particular political community and living under the laws that govern it. Okay. So basically, you have these rights under that state. It says, as you can see ahead, the community, through the agency of its laws. Okay, so the community, the political community, the political structure, through the laws, grants or denies rights. Okay, so it is the state or the structure or the community that either grants or denies rights. Okay, it is rights considered in this political sense. So there's a political sense in which you're understanding this, because you're thinking of rights because of the structure that are invoked when, for example, a court asks whether a suspect's rights have been violated. And then it gives you examples such as these are legal rights, and it tells you these are legal rights. Okay, it's telling you that these rights are legal rights, such as fair trial, freedom of unwarranted search, etc., etc. Okay, and it says these rights are grounded in statute or in constitution. Okay, but it goes on to say, as you can see later, that it is obvious that this sense of rights, which means the sense of rights as legal rights that are present in statutes, cannot apply to the more general human rights prescribed by international law, because these rights are often absent from the statutes of many nations. So this is, there are many countries, right, that don't have these rights written down. So if you want to talk about human rights in places where they are not written, this view is not going to help you, because this view functions on the premise that it requires to be grounded in statute or the constitution. Okay, therefore it says that there's going to be a problem, okay, because it cannot apply where the statute does not exist, where these rights are not written down. Okay, and then you see in the final sentence that indeed it is this very fact that for many nations certain standards of treatment are not written down and easily violated. It says because it's not written, there's a violation, and therefore for this very reason you need to establish such rights in international law. So the legal rights are available in some states, but if you look at it in that way, there are some states where there is no law and then there's violation. Therefore you need to establish human rights in international law. Very good paragraph. It lays down a problem for you. It unfolds the problem. Let's see where this goes. Right. The third paragraph begins with an interesting sentence. It says, however, international law is something of a misnomer regarding universal human rights. So it says that with respect to universal human rights, international law is a misnomer. A misnomer means something that has not been named properly. Okay, let's go ahead and see why, because it's not been told to you before as to why, which means that they're going to say that ahead. It says the term, which term? International law, could currently be applied only to certain agreements amongst nations, not to mistreat their own citizens. Right? You can use this to tell nations, hey, don't mistreat your own citizens. But because it is rare for a nation to be willing to enforce the terms of such agreements against another nation with anything more harsh than economic sanctions, for example, say the threat of war, international codes of universal human rights cannot currently be said to have the force of law. Universal human rights, international codes of universal human rights cannot be said to have the force of law, which is why he is saying that it is a misnomer, because states are not willing to receive enforcement. So you're saying that, states are not willing to accept anything apart from economic sanctions. Economic sanctions means the kinds of punishments that are economic in nature. For example, refusal to trade. Right? You see that happening quite often. That's an economic sanction. So it says here that nations are unwilling to enforce terms of agreement other than economic sanctions. It does not have the force of law, because the force of law to be having a certain ability to punish you. And then it asks the question, does this render the concept of an international standard of human rights meaningless? We saw in the first paragraph, the first line, that it was a major problem. We are trying to look at international human rights. So it's saying, does this become meaningless? Let us go ahead and see how it unfolds. It answers the question immediately. It says, no. Does this render the international standard of human rights meaningless? No. And it goes on to explain. It says, for it may be misleading, while it may be misleading to think of such standards as analogous to the legal codes of sovereign nations, they do express a valuable conception of rights. So it says it is not very similar. It's not similar. It's not analogous to the statutes of nations. Let's say like India has some laws. India is a sovereign country. So it's not similar to that. Yet these international standards do offer something valuable. So it's not meaningless. Okay. Foreseeing rights as political constructs is surely not the only way to view them, right? So you saw, we'd seen a little while earlier one view, and I said there's going to be another view that will follow somewhere. Here it is. It says seeing rights as political structures is not the as political constructs is not the only way or even the most fundamental. Okay, so it's saying that this view is not the only and it is not the most fundamental. Okay, which means that maybe he's going to talk about something more fundamental, right? Read actively. Okay, it says before governments establish legal rights in any written law, they must grapple with the question of what rights people ought to have, right? Before deciding before you establish the law, you need to see what is it right, what should the rights be, what should they be. It's a question that they have to choose amongst many rights that predate any statute or constitution and are thus not defined by law. Now what is being said here is that before you decide how to give a law and how to establish the law, you have to see that, hey, there are so many possible rights. Okay, out of these numerous rights, which one do you give and which one do you not give? This is a question that predates, which means goes back to, I mean, it's even behind in time. Before any statute or constitution, let's say for example in India, you had the constitution coming into force in 1949, 1950. Okay, it gives you a certain number of rights. Maybe it gives you these 5 rights. Okay, now the question is that how did the constitution decide to give you these 5 rights? Maybe there were 100 rights. Now choosing the rights that should be given is definitely something that happened before this. As it says, it predates any statute or constitution and thus are not defined by law. The procedure, the process by which it was decided that these 5 are to be given out of these 100 is not written in law. And then it says this points to a moral as opposed to a legal conception of rights. So the second view is the moral conception of rights. Okay, and then it says that this points to a moral conception of rights that international law may help us recognize more readily. So is it meaningless? No, it helps you recognize the moral conception of rights. And then it says that even if it lacks the power of a statute, an international standard can nevertheless stand as a moral guidepost for all governments and their citizens. So it says, although it may be a kind of a misnomer to call it a law, it still is there and serves a very important purpose as a moral guidepost. Okay, now we've been able to read the entire passage. Let us go ahead and attempt the questions. Right, look at the question. It says, which one of the following most accurately expresses the main point of the passage? Let me ask you this. If you've read a passage, should you not know the main point of it already? What I mean to say is that when trying to find out the main point of a passage, if you have to go back and look at the passage, it definitely means you've not read the passage well. So that's actually a bigger concern. So what I am trying to emphasize as of now is that for a main point question, you need to rely on what you remember, what you can recollect. Like I've said, rely on your recollection. Okay. Another tip that I can give you for these main point questions is that the main point of the passage obviously will not be confined to say one paragraph or one line or one word somewhere in the paragraph and in the passage. It's going to relate to the whole thing. Likewise, we'd seen that most passages, including this one, present 2 views or more than 2 views. There's the opinion of an author as well. Okay, so when you're seeing this kind of a question and you're looking at a main point question, you should know that these main point questions will give you both sides. Maybe not to the same extent, but it will present both sides. It will kind of tell you the author's opinion, and it will not be too specific. Once you've identified these markers of the main point of the passage question, spend some time, pause the video, and try to see as to which one the right answer is. Okay, option D. As you can see, it checks all of it ticks all of the check boxes. You can see here it says that despite the fact do not have the force of law. So here it's kind of considering the first view where you see the law, human rights as being a legal device only, from only the sense of the law. But it goes on to say that international standards highlight a moral conception. So it's giving you the moral conception as well as the legal conception and provides a direction. So what is the author's view? He says that even this international standard has some value. It provides you a moral guidepost. So you can see that everything that is spoken of in the passage is given to you here. If you look at any of the other options, you'll find them to be either irrelevant or maybe too generic. Let's take an example. Maybe let me just take option A. It says, unless nations become more willing to enforce human rights agreements with strong sanctions, it is unlikely. Look, do you see? This is not something that you find in the passage. Okay, this looks like a prescription that's going beyond the passage, and also it doesn't deal with the entire passage. Let's look at option B. It says, while it is generally believed that human rights emanate from statutes or constitutions, there is a set of moral laws that predates the establishment of any political structures. You see, this is correct, but is it the main point of the passage? What you are just saying here is that there is another view, okay, but it doesn't tell you anything more. You have to look at the one that gives you most accurately the main point. Okay, so while this looks okay, this is better. You're looking at the most accurate option. Okay, so you need to ensure that you need to look at all the options and pick the best one. Let's go ahead. Right, look at the question. Not very easy. Okay, understanding the question statement here is not the simplest of tasks. It says, it can be inferred from the passage that the author views the level of enforcement between nations of human rights, universal human rights, as evidence that ta ta ta. We have the options thereafter. What does this mean? It says, it can be inferred from the passage that. Well, it has to be inferred from the passage, so let me just make my life a little easier by striking this off. Obviously, it's from the passage. And you know that whenever you're looking at an inference-based question, you have to see what you can draw from the passage, not beyond it. So I struck that off. Even if it weren't written from the passage, you'd have to treat it as it being from the passage. So it can be inferred that the author views. So you're looking at the viewpoint of the author. Let me just strike this out also for the timing. It can be inferred that the author views. It can be inferred that the level of enforcement between nations, okay, is evidence that. So the author views the level of enforcement, right? So the author views the level of enforcement. The author sees this as evidence of what? You see, the author is treating the level of enforcement as the evidence of something. Now, what do you look at? Why do you need evidence? You need evidence to make a point, to prove a point. What you're being asked is, what is that point? So what is the point that the author is trying to make? What can you infer that the author is trying to see or trying to substantiate by citing the level of enforcement as evidence? Okay, this is what the question means. So when you look at the relevant part of the passage here, where it talks about enforcement, you can see here that the passage says that it is rare for a nation to be willing to enforce the terms of such agreements, okay, with anything more harsh than economic sanctions, which means that it says that, you know what, the sanctions are kind of very mild, okay. And then what does it say about it? Like I said, when you're seeing a paragraph, the first line of the paragraph really gives you great insight. What is the first line of the paragraph describing international law as? It is saying it is a misnomer, okay. Regarding human rights, it says international law in the context of human rights is a misnomer. So it's saying that, you know what, and you know the paragraph, the later parts of a paragraph generally go to explain what was introduced in the first line of the paragraph. So the first line of the paragraph is saying that, you know what, as far as universal human rights are concerned, international law is kind of a misnomer. It's like a wrong name, okay. It's kind of misleading, okay. And it goes on to say that, see, when you look at how nations enforce, they're really unwilling to get harsh. You know, they only apply economic sanctions. Once you've understood this and you look at the options, you can see that the word misleading in here, right, helps you out so much. It's misleading to describe the standards of human rights as laws, because, you know, when you have a law, then you really want that law to have the power of punishment. But in this case, it's not so. So you see that this is what the author kind of thinks, and you find that in here, right? Let us go ahead. All right, which one of the following does the author assert about the notion that rights are political constructs? Now, when you see the relevant paragraph, okay, and you're talking about what does the author assert about it, which means the author actually says it, right? You can see here that the author is saying that one view is that this, okay, it's very simple. The author about political constructs, which is basically saying that, you know, you see things as legal rights, as political structures. He's saying it's one view, and once you've seen that, the answer is so obvious. the, the, the author is saying that it's only one way of looking at rights. Simple. Let us go ahead. Right, so the question reads, the valuable conception mentioned in the second sentence of the fourth paragraph refers to the view that rights are, okay. You can see here, second sentence of the fourth paragraph, you can see here that it talks about the valuable conception. Okay, it before that it asks you, is this conception meaningless? And then he goes on to say, no, it is not meaningless. It provides you something valuable. Okay. And now, what is that valuable thing? It goes on to tell you that rights can be seen not just as political constructs, not just on the basis of political structures. It says, as you can see here, that it points to a moral as opposed to a legal conception of rights. You can see the word conception. So you know that it says it's not meaningless, which means it has some meaning, it has some value. You can also see the word conception right in here, right? You can see conception here, and it also gives you conception here. So you know that it's pointing to a moral conception of rights. So now when you look back at the question, it says, to the view that rights are, the answer is obvious, moral. Let us go ahead. Right, so this is the last question of the last passage in the free law prep mock test. Let's go for it together. The question reads, which one of the following can be inferred? Okay, so when you see an inference based question, you know that you're looking at the passage, you will draw from the passage. It's unlikely to be something that's really given as such in the passage. That's why you're inferring it. But that doesn't mean that you go beyond the passage. It has to be based on the passage. Okay, it says, which one of the following can be inferred from the passage about the relationship between the rights in the political sense and universal human rights? So it says, you know that there are rights that can be conceived in the political sense and then in the kind of moral sense, as you see in universal human rights. What is the relationship between these? Obviously, you know that the answer kind of lies somewhere in the last paragraph. Let me show you the relevant lines. There you go. It says, before governments establish legal rights, they must grapple with what it ought to be. Okay? And that is based on a moral conception of rights, which international law and therefore universal human rights could help us with. So before establishing rights in a political sense, right, before doing this, you need to grapple with the problem that is of the nature of international law, of the nature that international law can help, in which the sensibilities that are required in universal human rights could help. Okay? Once you understand this and you look at the options, you can see that the answer is B. It tells you that rights in the political sense have their basis in universal human rights. Now, in this case, what you've seen here is that you've seen words such as predate, which means it's there before. Okay, you've seen that there's a prior question that they have to deal with, right? Before that, you have to deal with this question. Okay, it does not really say that they have their basis in human rights, in universal human rights, but that's the inference, and it points to it quite firmly. Therefore, B is the answer. When you look at the other options, you can see that they really don't make so much sense. They aren't based on the passage. So B is definitely the best answer. You can, again, we've done all the passages together now. A word of advice that I can give you is that when you get a question wrong, remember that this question is telling you something that's wrong in your approach as far as the LSAT India is concerned. Use every wrong question as an opportunity to refine your skill and improve yourself. I wish you all the very best.